Okay. Good afternoon, everyone. I'm Sanaya, and I'm Zeit's Chief Legal Officer. And usually you guys have to suffer through me speaking to you guys about web scraping laws, but I've put together a nice panel for you today. So going to quickly introduce them, and then we will get into the topic. We're going to focus a bit on AI and IP and, of course, web scraping laws today. So first, next to me, I have Nikos Minas, who is the Global IP Counsel at Wesco, which is a Fortune 500 company. And then I have Justin Yuta, who's the Professor of Intellectual Property Law at UCD. And last but not least, at the end, we have Callum Henry, who is a lawyer on Zeit's legal team. So he gets to work with me every day thinking about web scraping, AI, and IP laws all the time. But I will let them all introduce themselves a little more, and then we'll get into it. So Nikos, do you want to start?
Yep. Hi, everyone. It's great to be here. Great subject as well. I work for Wesco now for 2.5 years. Wesco is a supply chain company. I mean, if you imagine that you want to build a data center, actually you call Wesco to bring all the electrical components that you need to build a data center. Now, they are transitioning very basic business. I mean, you are moving stuff from one warehouse to another one, but they are transitioning to a digital company. We want to become a digital technology supply chain company. And AI, of course, plays a big role in what we are doing and how we deploy our advantage. Now, my role at Wesco is literally to look at every IP aspect. So I will look from patents, trademark, copyright, and of course, because we have AI, I need to also do the compliance as well. Right? Now, my background is in engineering. I have a PhD in electronics. So many moons ago, okay? And I'm not going to tell you how many moons, but we were looking at early convolution networks, nothing like what we have today. When I was doing my PhD, we were playing with image recognition. I wish I had known that it will take off. I mean, I really did. NVIDIA was coming up, it was extremely cheap. Anyways, lost opportunity. But it's quite interesting because I can understand a little bit the technical aspect as well. Nothing like you live it every single day. But yeah, that's my job. Yeah.
Thank you, Nikos. Justin?
Yeah. Hi, happy to be here. My name is Justin. I'm a legal academic, which means I don't do much practice, quite frankly. So my background is in intellectual property law, with a multi-jurisdictional set of experience from Germany, where I graduated, then worked a bit in Luxembourg in the UK, and now here in Ireland. My initial interest historically before AI came along was copyright and creativity, so the old type of copying and cumulative creativity issues that arose in the early 90s, early 2000s, and so on and so forth. And then more or less the last 5 years, I was forced into AI. That also, of course, then includes not only copyright issues, patent issues, trademark issues, but also the entire regulatory environment. And we are now more or less looking into not only copyright law, AI Act, but the entire surrounding regulatory framework.
Great. Callum?
Hi, everyone. My name is Callum. I'm a senior legal counsel here at Zeit. Before Zeit, I trained as a media litigator, and I worked in media litigation for a few years before joining Zeit. And here at Zeit, I help the business develop the AI technologies that you all know the technological aspect of far better than me. But we work on the legal aspects of those with the product team and the tech team. And I also support our customers with all of their projects, ranging from e-commerce projects to training LLMs.
Great, thank you. So as you'll see, we have a lot of kind of IP lawyers on the panel, people who specialize in AI laws. And the reason for that is that's where we're seeing a lot of progress happening right now, right? There's a ton of IP litigation across the globe. There's actually a couple interesting cases we'll talk about. One case that came down yesterday in the UK. And so that's where we're seeing a lot of the developments happen. So that's where we want to focus and try to give you guys some practical tips as we go through on what you can do in your web scraping journey. But before we start, I'm going to give our classic, yes, we are all lawyers. We are not your lawyer. So none of this is any legal advice. It's just, best practices and guidance based on our experience. So we're going to kind of focus on two streams today of AI and web scraping. The first is if you are building a web scraping tool that uses AI, or if you're using one, right? We talked about Zeit's Copilot today. If you're building something like that, if you're using something like that, what are the AI laws you need to be thinking about? What should you look out for? And then the other stream we're going to talk about is, okay, I want to build an LLM. I want to scrape a bunch of data. I want to put it into an LLM. What am I allowed to do? What am I not allowed to do with that? So those are the two kind of streams we're going to talk about. And in order to talk about that, we need a little bit of background on AI laws. And so thought we'd kick it off with something very general, which is this AI Act that everybody's heard about, right? What is the EU AI Act? Who does it apply to? Maybe, Justin, I could start with you. Give us a little background. What is it, and does it apply to me?
Okay, but I'm not sure if it applies to you.
Well, not me personally.
Well, the AI Act is a relatively young piece of legislation which doesn't solve all the problems that AI creates. Actually, quite few problems. The idea of the AI Act is to prevent and address certain risks that AI poses to larger society. You know, we call that a risk-based regulation. It forces certain providers of AI systems, AI models, to comply with certain obligations, transparency, disclosure, but also establishes certain oversight mechanisms that are built into a tiered risk system. So we have, under the AI Act, a number of classifications, AI practices that are prohibited, that we cannot engage in, for example, subliminal techniques, that we try to trick people into doing certain things with AI that they don't really want to do, including marketing, also specific systems that are geared towards vulnerable communities, children, people of certain minorities, and so on and so forth. So some things we simply cannot do because we decided in Europe that we shouldn't be doing those. And then there are other types of risk categories. For example, there's a specific category of higher risk systems, products in the medicinal sector, and so on and so forth. And we also have a category for special general purpose AI models. And depending on in which category you fall as a model or system provider, you will incur certain obligations. If I had 4 or 5 days, I could walk you through all of them. But this is, I think, everything you need to know. There is one category which probably applies to most AI systems, which is a low or no risk AI system. And there is virtually no regulation in terms of strong substantive law, but these communities are then encouraged to draft codes of practice. It's kind of like a self-regulatory approach. If you don't adhere to these codes, nothing really will happen, but it's kind of an encouragement for for certain sectors to think about common standards. We have this from other areas as well. But this is more or less the run-through. The main obligations are for larger systems, make sure that you keep records, that you are transparent, and every now and then you want to have these records ready when certain institutions at European and national level that have been designated can essentially audit you as a company. If you're on high-risk systems, every now and then, say, the EU AI office or the national offices do actually have inquisitive powers to check whether you're complying with the obligations under the AI Act. That's the AI Act in a non-legal nutshell.
Perfect. And say I'm in the US and I'm building a high-risk AI system and I want to sell it into the EU. Is the EU AI Act still going to apply to me?
Do you want to take this one?
Nikos is like, yes.
Oh, it will apply to you, yes, absolutely. And that's the distinction you have to make. It's the deployment. Once you deploy something in you have to comply. And the risk-based system is self-assessed, right, as well. So none of the EU office will not come to say to you, you know what, you are a high risk. This is what you should do. It's up to you to define where you are in the tier. And this, I think, will be an issue. Because, as we all know, we are human beings, and we tend, basically, when there is a risk, to maybe sometimes minimize that risk, and especially go for the reward portion. Now, that will bring issues. We haven't seen anything yet. It's very new. Wait a couple of years, and you will see what will come out.
A little bit like GDPR. We had to wait a little while to see how things play out in reality.
Absolutely.
Yeah.
Absolutely.
And so maybe direct this one to you, Callum. We heard earlier in a really good talk about the dead internet theory and who, he talked about who the EU AI Act applied to there as well. And he said it doesn't apply to individual people. So individual people doing these bad actions aren't aren't regulated. And I thought maybe we could clarify that a little bit. They're not regulated under the EU AI Act, but are they regulated at all?
Yeah, I mean, there's a slew of laws and things that will apply to you. I mean, the first thing with the AI Act is it does apply to individuals, but it doesn't apply to individuals if you're using it for your personal use. It only applies to you if you're doing it for a commercial use. But in terms of what regulates what you do in society and on the internet when you're using AI, all of the existing laws that regulate your behavior in society will apply. There's fraud. Can you deceive people? There are civil and criminal potential liabilities in fraud. There's defamation. Can you say what you want, even if it's an AI thing that writes it for you? No, you can't say what you want. You might be sued for libel in the UK. There are malicious communications. Can you abuse people online? No. So there's this whole sort of framework of regulations that already dictates what you can and can't do in society and online that still applies to your behavior, whether it's you alone at your computer or whether it's you using an AI at your computer. So it's a little bit more nuanced than that.
Yeah. So yeah, it's good to note that AI Act isn't the only thing that's going to regulate how and what you do with AI. There's still a ton of other laws. But if we do focus back onto web scraping and the EU AI Act itself, Justin laid out those risk levels really nicely for us. So let's go back to, I am building this great AI web scraping tool. Where do we think that sits in the risk levels?
Well, actually, let's put it to the audience.
Okay,
so
that's a good question. Okay.
who thinks that web scraping sits in high risk? Okay.
Good job, you guys have been listening.
Okay, well done. What about what was the next? Limited, isn't it?
Limited.
General purpose.
General, yes. Yeah. Yeah. What about general purpose? I mean, is it? Do you think that is there any risk at all with web scraping? No. Okay. So it's somewhere, I think, in my opinion, at least, it's limited, right? Mm-hmm. I mean, you're doing web scraping, you're scraping data from the internet, right? But you still have the obligations that we talked about. If there is an audit, you will still have to have documentation, transparency.
Well, that depends.
Yeah.
I wouldn't say there is as much records that you have to keep that are necessarily laid down or they have to be laid down in codes of practice. No? So if, for example, all the web scraping companies band together and say we establish community standards and lay them down or even found an association, that would be lovely, but you don't have to expect extremely strong enforcement efforts from the European Commission or the national responsible institutions. The only thing that I would want to say is that if you do engage in web scraping, you want to see who your customers later on are, because they might fall under one of the risk categories. For example, if you feed into a GPAI, they have other responsibilities. So downstream, in order to sell your product, you want to make sure you keep the records, at least what things you're harvesting, how they're composed, and to enable others then downstream to fulfill their obligations under the EU AI Act.
Yeah, I think it's worth distinguishing between the sort of the front end and the back end. The extraction of data, if we're talking about as kind of what we've talked about today is the Copilot extension, which is an AI, an LLM-powered coder, effectively. And the interesting thing with the AI Act is that you sort of start at the end. Right? There are a lot of laws that you think about. You've got to start right at the beginning. Here, you've got to think about what is the end purpose of this thing. Then I can allocate it a risk. Here, we've determined it's not prohibited. It's not high risk. It might be this sort of limited risk category because you might interact with it in a computer way. It generates synthetic content, and that puts it in this limited risk. If we're talking about the LLM coding aspect, and that imposes on you some transparency requirements, as Zeit, this is something that we obviously considered when we developed this. You as users have to know that you're interacting with an AI tool. You have to understand that the code that is being generated is not being generated by one of our developers. You don't sort of put in a request and then we've got a whole team of people in a warehouse coding away saying, oh yeah, this is how you do it, and they can type faster than you can think. It is AI generated code, and we have to tell you that. Right? That is an obligation that on us exists under the AI Act because of the risk category that we put this in. There's also training that we have to do internally as if you're a developer of a tool that is allocated to this risk. But I think it's worth separating out the generation of a tool. This is an LLM code generation tool, and then the downstream uses, I think, is probably something that we're going to come on to.
Yeah, and certainly, at Zeit, we do have a tool like this, other companies have tools like this, and we do think about what our end users are gonna do, and we still think about kind of the broad spectrum of web scraping laws that interact with that as well. So I think we've got, okay, it's limited risk, you've got some transparency requirements, don't pretend you're not an AI tool. If you're an AI tool, say you're an AI tool. So we've got some guidance, but now I'm a consumer. I want, a lot of you are doing web scraping. I want to pick a tool to use. Are there considerations around picking an AI scraping tool that you should be thinking about, and what might those considerations be? Callum, you probably deal with that more than anyone else here.
Yeah, I mean, there are tools on the market that will generate this code, but I think it's important to remember that you are still responsible for what you do on the internet and the way that your crawlers behave and interact with the websites that you're accessing, even though it may not be you that has directly coded or written the spiders, the crawlers, and the extraction. So then we have to step back and look at what are our kind of basic web scraping legal principles. And there are a few, and if you've ever been to an Extract Summit before, you'll have seen Sinai talk about some of these. So there's copyright. What data are you accessing? Is it potentially copyrighted? Where are you, and what are you doing with it? Are you in the US? Might it be a fair use? We'll come on to that. Are you in the UK? There's personal data. Are you extracting the personal data of EU residents? In which case, are you doing it in a way which is compliant with the GDPR? There's database rights. There's this whole sort of slew of basic web scraping things, and there's also interacting in a respectful way with the websites. It's something that we're quite strong on at Zeit. Is in order for this industry to succeed, we have to interact with the web in an ethical way, and that means writing that your crawlers in a way which you're not going to overload sites, you're not going to damage the way that websites are available to their consumers. So there's this whole regulatory framework that already exists, that just because you're using an AI tool to write your web scraping code, it doesn't absolve you of the responsibility to interact with the internet in an ethical way and in a compliant way with the laws that already exist.
That's perfect. Thank you. So yeah, always go back to your web scraping best practices, because those remain important regardless of the tool that you're using. So now we're going to kind of move a little on to copyright laws. This is a big thing in the context of AI and web scraping. This is where we're seeing a lot of litigation and a lot of interesting things happening. We'll kind of talk about the EU and the US here, because they are a bit different, and we want you guys to understand those distinctions. But maybe, Nikos, I could start with you. Just tell us a little bit about maybe how the copyright directive affects web scraping. The text and data mining opt-out comes up a lot. Talk to us about some of that.
Before we do that, does everybody understand the copyright? Is that what we're talking about?
Quick copyright definition.
Yeah? So it's if I created something and it's original, I have the copyright. I own it. Now, in the US it's a little bit different. You have to register it as well. But nevertheless, you own it. If Justin over here wants to use what I created, he has to come and ask my permission. Justin, anything to add?
In principle, that's correct, yeah.
Yeah, okay. So, whenever we are scraping data, someone has created the data that you are scraping.
Unless it's factual. Not
Unless
everything
not
on the
everything.
internet
Yeah,
is
yeah,
copyrighted.
We will go to there. We will go to that as well. Okay. So there is, you have the copyright, the common law, for example. I mean, there is no problem at all. Fair use. I mean, so if there is something public available, you can use it. But there is an issue. So normally you don't differentiate. You want to scrape as much data as possible that is relevant for your purpose, right? And this is where you need to have the check and balances built into your tool. You need to know if you are accessing a website, have they opted out from the text and data mining? So the LLM that will access the website needs to access the code and see that, no, I cannot really do that. I have to go to another website. Because if I extract the data, which you can, then you are not compliant anymore, right?
And that's a specific EU principle.
That's a very specific EU principle. So in the EU, it's all about accountability. Where do you get your data? Now, in the US, a little bit more, it's different. I mean, it's later on comes down in court. I mean, you first build it, and then someone might litigate you, as we have seen, right? So that's the principle. And you need to have built this kind of check and balances into your LLM tool. And that's quite difficult. So it's, in itself, it's how do you differentiate? I mean, what do you have to go to the terms of service, for example? What's a service? We were discussing with Callum as well. Is it something that you are accessing database or not? So an LLM will not be able to differentiate. So someone has to do that job afterwards, I would say, right? When you clean it. So that's, I think, yeah.
Anything to add there, Justin?
Yeah, just to contextualize this to a certain extent, the opt-out notion. So you said it's something that we only have in the European Union. That's absolutely true. It's a very, very weird solution. So one way not to be required to ask for permission is if you can rely on a law that expressly permits that you perform a certain act. Although in principle we call that prima facie, it's prohibited. The law can say in certain circumstances you're allowed to do it without authorization. In Europe we have Article 3 and 4 of the Copyright Directive, which have to be distinguished because they apply to different institutions. Article 3 applies to research organizations, whatever that is. We don't really know this so far. Public-private partnerships, most likely not. Universities, very likely yes. And they can do whatever they want to in terms of text and data mining. They're allowed for scientific research purposes to text and data mine, web scraping and so on and so forth. For commercial text and data mining, we have a special provision which says in principle you're allowed to do it unless the right holder opts out. Now, the main question we discussed over the last 2.5 years was, how can you, in a situation where you have a small little machine running through the internet, that's how we understand it as lawyers, tell that machine not to scrape the data? And from what I understand as a stupid non-tech lawyer, you have a robot.txt line somewhere in your code that indicates to the machine, please don't farm here, which I understand you can simply ignore. There has been, and this makes everything much more complicated, and this is why I highlight this, a recent ruling in Germany which applied this provision, which said the declaration whether, as a right holder, you do not want to permit web crawlers to index, but also to farm your data. It doesn't have to be machine readable in the sense that it is a coded instruction, but it can also be written in natural language into, for example, the terms and conditions of the website. And that then makes it much more complicated for you guys, because you have to have a web crawler that not only looks for robot.txt, but also speaks, we don't really know, 27 different languages within the European Union to identify whether somebody in non-legal language says, please don't copy the stuff that I have on my website. And this, of course, creates huge issues for the tech community to adapt to legal standards that are still in the process of emerging. You know? And this is why nobody really likes this. But again, this is interpretation that is in evolution. There's one ruling so far on this issue, and that was also what we call an obiter, a non-legal binding part of a ruling. So it makes it even more murky and uncertain to rely on. In the US, it's easier. It's a full-in solution, but you never know before whether what the Americans call the fair use doctrine applies to a specific activity. The Americans say we don't write specific cases, text and data mining, in the law. We give you 4 factors on which everybody can then for themselves see whether, grosso modo, the activity they are performing in relation to a work or works protected by copyright is fair in the sense of the fair use doctrine. And there we have an interesting landscape evolving in the US currently, where this is tested against a number of different contexts.
Yeah, and that actually brings me right into to some of the US law, right? We've talked a bit about the EU, and look, it is a little bit stricter here. It does start to get a little more concerning from the web scraping perspective, but again, it's still all really murky, right? Like Justin said, this isn't binding law that he's talking about. For the most part, robots.txt are still looked at as, advisory and not legally binding. So it's still very gray, but in the US, there's some interesting lines being drawn, and probably the case that everybody's talking about right now is the Anthropic case. I talked about it in Austin a little bit, but we'll go into it here. Very quickly at a high level, Callum, do you maybe want to give us, what does the Anthropic case say in a nutshell?
Again, something we could do a whole talk on. But in a nutshell, there are a lot of issues were covered in problem with some of these cases is they're quite fact specific. So we're taking sort of really general guidelines from decisions that were made on specific facts. But Anthropic, what the judge was dealing with is the training part of the model. And what Anthropic did is two separate things the judge looked at. So they bought a load of books, physical books, they ripped off the bindings, they cut them, they cut off things like page numbers and headings, and then they scanned them. And then separately, they downloaded a load of torrented, pirated books. And the judge had to deal with the different legal analysis of whether those two uses to train a model on those two different sets of data fell within this US concept of fair use. And where the judge came down was that actually the scanning of the books, right, there was a one-to-one relationship between the digital version and the print version. And the training of the model on those scanned books was entirely transformational. And whether something is transformational is one of these factors under US fair use. So where the judge came down on the books is that actually, yes, training an LLM in the US on legitimately obtained books in that way was a fair use. Now, there was a very different decision on the pirated books because these were obtained unlawfully. They had a significant effect on the market, right? Anthropic could have gone out and bought all of those books. Instead, they downloaded them for free. There's a massive effect on the market. So you still have this transformational thing, but the thing with these four factors is that it's all weighed up. But on the pirated books, where the judge came out was that on all four factors, it fell against fair use. So we've got this distinction now between lawfully obtained data and unlawfully obtained data, and this pirated content point is probably the most significant clear piece of guidance that as lawyers we can give at the moment is be very, very cautious with training a model on unlawfully obtained data.
Yeah, and I think one thing to note there also is kind of like how we were talking about the EU decision wasn't binding. The judge didn't make a binding ruling on the pirated books. It was just, this is likely to be my decision if this case goes forward. And so Anthropic has wisely decided to settle the matter rather than have the judge make that final ruling.
For a very reasonable price as
Oh,
well.
very
I have
reasonable
to say,
price.
I mean, you know,
Yeah,
I
what was
was surprised. I mean,
1.5 billion?
1.5.
1.5 billion? Yeah.
But I mean, you know, they're worth now what? Is it 300 billion now in terms of capitalization? I mean, you know.
Probably.
I think the statutory would have been into the trillions.
Yeah, exactly. Yes,
Correct.
that's exactly yes.
Had they litigated the full suit, the damages would have been in the trillions,
Yeah.
and they settled it for 1.5.
Exactly, yes.
So,
So,
not a
well,
bad day in court. Right?
Exactly. Yes, I think so.
But it does show you how important it is to stay away from those pirated sites, to be cognizant of what you're scraping, right?
Yeah.
Back to the point of even if you're using, these AI scrapers and they're going to build these really cool spiders for you, you still have to think about where that's going and what that's doing.
Yeah, the source definitely. I mean, you know, that's the.
Yeah.
Where do you get your data?
Where you get your
That will be
data,
your primary concern, and it should be your primary concern.
And I think we've seen maybe a couple more cases that show us that. We certainly have looked at them at Zeit on the U.S. side, on the pirated side, right, Colin?
Yeah, I mean, there are two more that we're looking at. There's one with Salesforce, and there's a class action against Apple, and both of them are on this pirated content point. And look, it's really, in the judgment, there are loads of messages that came out from Anthropic where they're talking about, oh, it's great, we got all of these books, we've got absolutely millions of pages, and we just got them for free immediately, right at the beginning. So it's, the problem is, it's right at the beginning, it's before it was the Anthropic that we know now. It was when it was, a few guys, and it usually is, who download, and they can get all of this content for free immediately and start training this model. So you can see why it's appealing, but it is the area where we're seeing probably the most likely area of success at the moment, particularly in the US.
Great. And the good thing is there is this fair use doctrine in the US. There is this concept that if you do lawfully obtain the data, so we haven't seen it play out in the concept of, okay, I lawfully scrape data from a lawful site. But that's kind of where the judge's ruling was leaning towards. But so it's nice that we have this fair use concept in the US because it means you have a defense to copyright infringement. But what if you're in the EU? Is there anything similar in the EU?
Go ahead. Yeah, go ahead.
Yeah.
In these specific cases, not really. So we have to rely on the provisions I mentioned to already. Maybe one final point to make in relation to the European Union. You should, however, be careful how you get your data under the stricter provisions, because although you might simply, and we haven't really talked about this yet, is an issue in the Getty case that was decided 2 days ago, 1 day ago.
Yeah, it was going to be my next question. So if you want to go into the Getty case, feel free.
Very briefly. There is an obligation under EU law that subjects the marketing of an AI system or an AI model in the European Union to compliance with EU copyright rules. So although you might train your model outside the European Union and therefore don't infringe copyright in the European Union, if you then want to market your model in the European Union, again, evolving jurisprudence, you will still have to comply with EU rules. So it doesn't mean that you can do everything in the US and then market in the European Union. You have to be a bit more careful. From a doctrinal perspective, we don't really know how to position this, whether it's regulation or copyright infringement, but it also indicates that you might want to find a solution that makes you compliant with at least copyright law throughout the markets in which you want to market your product.
Great, and let's maybe stick with this Getty versus or Stability AI and Getty case where Getty sued them for using their images, right? Getty Images has like a whole host of images. Stability used it to train their model, and this case was in the UK, and the ruling just came out yesterday. It was a light 250 pages of reading, so it was very fun for everybody to skim it and try to catch up before we chatted today. But what generally did that say? Probably all of you know generally what it said, so any of you can take it who wants to. But what were the rulings that came out of it?
Yeah, I mean, it's a really interesting case. It's an image one, so it's a little bit different to the Anthropic case that we've talked about. I mean, the allegation is that Stability took all of the stock images on Getty's page, because what you can do is you can access these images without buying them. Once you buy them, then they get rid of the watermark and you get the full resolution. But what they did is they trained the model on all of these Getty images, and Getty brought a claim in the UK for training the model using this. And that portion of the claim is not what was dealt with in this 200-page judgment, because what Stability said is that we didn't do that in the UK. The images never touched a server in the UK. They were only ever on AWS in the US. So we can get rid of that. And that was pushed off, and Getty dropped that aspect of the claim halfway through the trial. So that we don't have any clarity on. So what was left was a trademark point, and the trademark point is the Stability AI software was able to reproduce images with the Getty watermark on it, right? Because it had seen so many of them. You could say, I want a picture of Obama next to a helicopter, and it will come up with Getty on it. But usually it was like Getty with 3 T's, or it was Getty Images, and Images had 3 I's. So it was kind of this like really mashed up version of the Getty watermark. And what the judge found there was that it was a couple of points. One was that the watermarks were quite far from the real watermark, right? Because it had 3 T's or it had 2 I's. Yeah. And second, that there wasn't any evidence that anyone in the UK had actually done it, which is a bit of a tangential point because the likelihood is someone in the UK did create that watermark. But the judge ultimately dropped that point. The more interesting point is this copyright infringement point. Now, in the UK, the law distinguishes between primary infringement, which would have been, in this case, copying the images to train the model, and secondary infringement, which was what we were left with, which is Stability importing the model into the UK once it had been trained. And what the judge found, which is really interesting, is the exposure of the model in the weighting process to the images actually was not infringement, because all the model was exposed to and all the model retained was a mathematical representation of the image, right? It is this sort of grade, and I mean, you guys know this way better than I do, but it's effectively a mathematical representation of the image, and that is not a copy of the image, right? It's numbers. So under the UK copyright law, they found that could, in principle, a model be something which is capable of infringing copyright? The answer to that was yes, a model can be. But the answer in this case to was it infringing The answer is no, because the model never saw an image in the way that you and I understand an image, and it never retained an image, so it can't be a copy of an image. So that's something positive along with Anthropic for model developers.
Yeah. Justin, I think you made an interesting point to me before about the judge sort of caveated her ruling. Can you tell us just a little bit about that?
Yeah, there was one sentence in, I think, paragraph 64 or around that area where the judge said, more or less in my understanding, it could be different. So it doesn't mean that because, I think Smith was her name, decided that in this specific case that other courts will follow. It's simply her understanding of how it works. And there are other theories on, which then comes down to centuries of understanding what constitutes copyright infringement. Some judge could say that a statistical representation actually is a copy, depending on, and this will then have to be judged on evidence, how likely is it that you can actually provoke an output. And the follow-up question is then the liability of the system provider, or is it the liability of the copyright user? But these are all questions that still require addressing at some point in time. There are no laws on this, because the legislator is always very, very slow in reacting, and the interpretations will then be based on laws that existed pre-AI. There's nothing on that in the AI Act. I'm sorry to disappoint you. So this is something that we have to watch. My guess would be, and I can say, because I'm a professor, it's an educated guess, most judges will follow this interpretation, because it would be a far stretch to say that the probabilities that then help you to compose something that looks like a cat are not the reproduction of a specific image, but a learned in inverted commas, a learned understanding of concepts. And concepts are not protected by copyright. Ideas aren't protected by copyright. Only specific expression, i.e. a specific photograph or a specific text, would be protected. And deriving this out of a probability-based system is a very, very delicate argument that you have to make.
The only caveat I would give here is that this is dealing with this secondary point. What has not been dealt with by the UK and what is remaining in the US is Getty's claim against stability for the actual training. And what the judge is going to focus on there is that initial copying, right? Is the taking from the website and storing on your AWS server the original image. And that is what we would in the UK call a primary infringement. And that is what hasn't been dealt with. And if we were to take a slightly less educated guess for me on what judges would find, is that would be infringement, right? It's straight up copying.
In the UK, in the US, you probably still have a fair use argument you may rely on. I am going to have to cut us off a little bit, though, because we have a lot of questions here and only a few minutes left. So maybe let's just go into some of these questions. There's some very interesting ones I'm just going to pick randomly. So this one says, most AI agents, like ChatGPT, mention that they don't support scraping. Why is this the case when enterprises can scrape, but AI cannot? Any thoughts on why we might think that is?
The only thing I would say is that the advice that you get from ChatGPT on web scraping is really crap.
It's real bad.
And it's weird because you think that AI is, if you pay a lawyer or you use an AI, you think you're going to get a more cautious answer from the lawyer. But actually you get a much more cautious answer from the AI. Yeah. What AI thinks is illegal for web scraping, we would say is very, very clearly not, and well established not. So I would take advice that you get from AI systems on
that's by design, right?
With a pinch of salt. Yeah, maybe.
That's by design.
To keep us in jobs?
That as well, I think, absolutely. But that's by design because, of course, if you provide advice that will be followed, and it cannot be seen as advice from ChatGPT, all right? Because, of course, OpenAI might be liable for that advice. And I think now the terms of services, they do clearly say, okay, look, this is not a legal advice, do not follow it, and so on. So I think maybe by design, yeah.
I want to ask a follow-up question. Does it state in the terms and conditions, or is it an output provoked by a prompt? Because that makes a difference. If the terms and conditions say we don't support scraping, that's an attempt to limit their own liability. Yeah. Because if you then use ChatGPT for scraping, then they can say it was a violation of the T&Cs and therefore we're not liable. So it really depends on whether you ask, do you support scraping? And ChatGPT says, oh, it's Monday, I like flowers. Different question. Because they cannot provide legal advice based on a model. But if it's in terms and conditions, that's limitation of liability, I would say.
Yes. Yeah. So I think that could be a bit of both.
Okay, great. All right, moving on. How can I avoid legal issues if a customer reuses or duplicates the entire content, including images from a website we crawled?
Draft your terms of service very carefully.
Yeah, exactly, yes.
Yeah.
There aren't any liability rules so far that would clearly apply. So I would write it very, very clearly. You're not supposed to do this, and then hope a court would believe you.
Yeah, I mean, that's what we do at Zite, right?
Exactly,
Our
yes.
terms of service are very clear on what you can and can't do. If you are doing the scraping for that company, for example, if like you're using Zite's professional services arm and we're doing scraping, we would look at what you are doing before we do it for you, and we would make sure we put protections in around that.
Yeah.
So you do have to be really cautious when you are providing that data to people. You want to make sure they're not running afoul of the laws either.
Yeah, absolutely. But that comes down again to accountability, right? I mean, how the end user will use the data that you scraped. And if you have built the right contractual clauses, the liability will flow to them. You say, okay, look, that's the data.
Yeah,
do.
but at the end of the day, anybody can sue you for anything. So
Oh,
while
yeah,
you
yeah, of
while
course.
you may not be liable, you could still get
Oh,
sued.
yes,
So
yes.
always try to protect yourself and make sure you have the right provisions in your contracts.
And if you know your customer is doing that, have a think about whether you want to continue letting them.
Exactly, yes.
Absolutely. Unfortunately, there's like a ton more questions, but we don't have time for them. But feel free to come chat with any of us after. Thanks so much.
Thank you very much.
Thanks, guys.